Hello, everybody. My name is Andrew Zwerling. I'm here with my partner, Marianne Monroy, from the law firm Garfunkel Wild PC, and we're pleased to give today's webinar entitled Reasonable Accommodation Training, the Interactive Dialogue. When Marianne and I checked out the registration list, which was pretty extensive, we saw there are a lot of returnees. So the introduction I'm about to share with you, for you returnees, if you want to take a sip of coffee, put this on mute for a minute or so. We won't take it personally. For those of you who are new to Marianne and myself, a little bit about our firm and about Marianne and me. Garfunkel Wild, we're a full-service healthcare law firm with about 90 attorneys in New York, New Jersey, Connecticut, Florida, and Washington, D.C. We've been around for going on 44 years next month. By full service, it's really soup to nuts. It's healthcare, litigation, particularly relevant to today's topic, employment, compliance, and so on. And we've branched out into other industries as well, away from our original roots. Marianne and I bring decades of experience together as litigation attorneys, employment attorneys, which means we both try cases, but also put on fires on a day-to-day basis for clients reaching out with employment issues of various description. And that's helpful because we can use what we learn in a courtroom where clients either did something well or not so well, and use that to inform our day-to-day employment counseling. Importantly, while Marianne and I take a lot of pride in the positive outcomes we achieve in litigations, a large part of what we do and take even greater pride in is problem solving with human resource officers, human resource directors, general counsels, in eliminating problems before they grow into something larger. A lot of the times we don't get that phone call until there's a lawsuit or a pre-litigation demand, and sometimes it's too late by that point. Our advice is contact us when the problem's small. Better you spend the half an hour, 20 minutes, an hour with us putting out that fire at that time than spending the years and substantial amounts of money, dealing with the litigation, whatever the issue may be. Before we start on the subject matter, because this is for CLE credit, I'm obligated to make this little boring spiel from the form for those of you who are putting in for CLE credit. The content of the course is acceptable for both newly admitted and experienced attorneys. Please be sure you continue to stay connected on Zoom until the program concludes at approximately 1 o'clock. You'll be eligible to receive 1 CLE credit in professional practice. For New York CLE attendance verification purposes, all course codes, and there'll be one, the course code is going to be announced at the end of the program. The program itself is going to be recorded on the attorney affirmation and evaluation forms and emailed by you to Ivan Rodriguez. For purposes of asking us questions, use the chat box at the bottom of the screen, and Marianne and I will do our best to answer those questions. But also in the chat box, it's there now, you'll also find the link to the evaluation and CLE forms that you're going to need to submit afterwards. With regard to question and answers, again, Marianne and I have given a whole lot of these presentations. We genuinely appreciate questions in the moment. We'll do our best to answer them. If not, you can catch us at the end of the presentation, or our contact information is in the PowerPoint, and you can reach out to us separately. We definitely welcome that. The topic, we're here to discuss the interactive process that employers must engage in with qualified individuals with a disability to explore what reasonable accommodations may exist under the Americans with Disabilities Act, which we're assuming certain base knowledge on the part of everybody, but the ADA prohibits employers from discriminating against employees because of a disability, whether it's job applicants or employees, and requires employers to provide reasonable accommodation to those qualified individuals with a disability, absent undue hardship. I mean, that's just the general framework. What we're going to talk about today is what's known as the interactive process, or the interactive dialogue, that conversation that you as an employer must have with your employee who has a limitation and requires that conversation to see whether or not there's some reasonable accommodation that will allow that employee to perform the essential functions of the job. Okay? The objectives up there: when must you initiate that process? What type of notice is sufficient to spark your obligation to engage in that conversation? How quickly do you need to act in response to the request? What are the steps? And it's not 100 of them, and we're going to walk through with you in detail what those steps require of you. When you should or should not ask for medical documentation concerning disability. And lastly, the interactive process itself for assessing what accommodation may or may not be available. All right, initial disability coverage issues. As you see up there, only qualified individuals with disabilities have the right to reasonable accommodations in the first place. Again, you have that absent undue hardship, and we're going to talk in more detail about that towards the back end of the program. And you have three categories or definitions of disability. You have actual disability, record of disability, regarding as having disability, and they kind of self-explanatory, but actual is just what it sounds like. If the person, the employee, has a physical or mental impairment that substantially limits one or more major life activities. The record of a disability is what it sounds like. An individual is covered if that individual has a history of a disability or is classified as having a disability. Regarding as having a disability really means individuals who you view or perceive as having a disability are also covered under the ADA. And as Marianne and I can tell you, that tends to be a problematic area with regard to the obligations of employers. But merely being regarded as having a disability is enough to trigger that protection.
Okay. I just want to point out, while the ADA has a very restrictive or limited version of what is a disability, and it has to substantially limit a major life function, state laws are more liberal and broader in the context of defining somebody as having a disability. So you want to keep that in mind, that what you may not consider a disability, such as maybe bronchitis, right? Here in New York, for example, the New York State Division of Human Rights might say, the person has bronchitis and a bad cough. Remember one time a Division of Human Rights investigator said, I'd like to hear a little phlegm with it, but we can consider that a disability. So, you really have to be mindful of that.
All right, the overview, once you're aware of the limitation, you have to have that dialogue, that interactive process to see what resolution can be reached that doesn't work in undue hardship on you as the employer. You see it there, the interactive process. What's the goal? Really twofold. What are the limitations, and what is a proper response to that limitation that will allow that employee to perform the essential functions of the job? When this conversation goes well, and the conversation or the dialogue can be pretty brief depending upon the situation, or protracted depending upon the situation. You never hear anything about the interactive dialogue. But if things go south, where you can't come to an understanding about or agreement about what is a proper resolution or proper accommodation, or the employer says, I think this is one and it doesn't work out well for the employee for one reason or the other, that's when exposure to liability starts to kick in. There's a question, can you require written documentation of this disability? We're going to put the answer on hold, but we're going to be addressing that expressly in a short while.
Absolutely. All right, so look, we totally recognize, Andy and I, that this area is really tough for clients and people who are trying to run a business, okay? And then it's not always easy to make these types of accommodations and deal with these accommodation requests. So we want to, go through as much as possible to give you a sense of comfort when you are dealing with these, and feel free if you needed us to help you walk through it, on a case-specific basis, we're happy to do that. So the first thing you have to think about is, when is your duty triggered to engage in the interactive process, right? So you have an employee, and generally it's when the employee asks for an accommodation. And I say generally because you may have reason to know, and that's going to trigger your obligation. But let's say, generally that the employee has the duty to ask, okay? That's going to be enough to trigger this interactive process, all right? But they're going to have to give you some more details, all right, with that. The request doesn't have to be in writing. It doesn't have to be totally detailed to just kick off the conversation. The request may even be made by a family member or someone else, okay? It could be a coworker of the employee that says, you know, so-and-so is going through chemo treatment and is having trouble doing such and such, right? That coworker of the affected employee could make the request. Special words don't need to be used. So what I mean by that is the employee doesn't have to say, I need a reasonable accommodation or I need an accommodation. It could be that I need a schedule change because I have medical appointments in the morning and I need to start, I'm requesting to start a few hours later, or maybe 15 minutes later, whatever it might be. That's enough to constitute a request for a reasonable accommodation, okay? The employee could say, you know, I have a foot injury and I need some time off because I'm going to be doing PT for a little while, right? That's enough to know that you have to now start to engage in the process. Okay?
Just to interject, as Marianne just said, that doesn't mean they get to do what they want.
Correct.
That means that that requires you to have the conversation about what is doable or not. Though it's just that they're putting out there, I have this need, that starts the conversation, doesn't end it.
Absolutely. So now you know that there might be this need. Now it's time to get some more information, right? What is the employee looking for, right? Are they asking for an adjustment to their schedule, a change of their duties, assistance at work, right? The employee has to provide sufficient information to understand what they're looking for and that the need is tied to a medical condition, right? So if they're just asking for a more comfy chair because it would be nice to have a more comfy chair, right? That's not, linking a disability or a medical condition to an accommodation request, okay? But if the employee has mobility issues and say, you know what, my assigned parking spot is in the furthest lot from the complex possible, and I'm having trouble walking, I need a closer spot, right? Now you have the specifics of what they're asking for, right? Okay, so now, an employer also can't remain in the dark if it knows what the employee needs, right? Every office has the rumor mills, the gossip mills, and information travels, right? So you can't pretend that you don't know an employee is suffering from a condition. If you know, then your duty is triggered. And remember, you can say, well, they didn't tell me specifically. If you are deposed and you're under oath, you're going to have to testify truthfully. Yeah, well, did you know the person had a heart condition and was struggling to lift the files to put them away? Well, you're not going to be able to say no if you did. So keep that in mind. All right. Then the information has to be even more specific as to what they're looking for as far as the nitty-gritty, the details. So you're going to ask them, okay, you want to leave early. What does that mean? Well, I have an appointment every Tuesday and Thursday, and I need to leave, I need to leave early. So let's say you grant them the ability to leave at 4 p.m. for their 5 p.m. physical therapy, whatever it might be. And you find out, or they tell you, and you think it's effective, right? You think that this is an effective accommodation, but it turns out it's not, because they take the train. By the time they get there, they've missed their appointment, right? So you're then going to have to revisit and get more specific information. And we're going to talk about documentation in a minute. But this is how the process just starts. It's gathering the information so that you can make the assessment. Then it's also important that the employee make the request in a timely fashion. Like, obviously the employer has to assess it in a timely fashion, but the employee has to make it timely. And what I mean by that is you terminate the employee for poor performance, and on the way out of the exit interview, they say, oh, I needed an accommodation because, you know what, my work was really poor because of X, Y, and Z, and you should have accommodated me. If you can, in good faith, say you had no notice, they never requested anything, you gave them opportunities to prove their performance, and you have the documentation of performance issues, well, then it's too late. You can't ask for an accommodation after you've already been terminated, okay? There are situations where if you, again, this goes on to if you had reason to know they might need one, you have to be careful. So I've had situations where employee caught sleeping on the job twice, employer terminated them, okay? Sounds pretty straightforward, that's fine. And then after the termination, the employee suddenly says, you know what? I was sleeping because I suffer from X, Y, and Z condition, or I'm taking medication, and I needed an accommodation. So it's easy to say, well, you should have asked, I would have done it, or we could have had that discussion, but you've been sleeping on the job, it's already done, it's too late. But again, it goes back to, did you have reasonable knowledge of it? Like, so if it could be tied back that a supervisor knew that the person was going through chemotherapy, right? It would be premature to terminate the employee having known that information. So if they were sleeping on the job and you knew they were in chemo treatments, right, you're going to have to engage in that dialogue. Let me see what the question is. You become aware from a supervisor as an example, but the topic is sensitive and the supervisor has directed them to HR, but they haven't gone to HR. Are we still obligated to look into this potential need for a reasonable accommodation, in particular when the employee either expresses to the supervisor or implies by the lack of follow-up that they don't want HR involved? Okay, so yes, and you can do it in different ways, right? Your obligation is try to engage in the dialogue. If they don't want to, or they don't want an accommodation and tell you that I don't need anything, your obligation is fulfilled. So and that was one of my next questions here. Like, if you're suspecting there's an issue, they are raising an issue, you still have a duty to say, look, it's come to my attention that you may have a condition, not saying that you do, but you may have a condition that requires an accommodation, or that you may be looking for an accommodation. We're here to help. We're happy to engage in the dialogue. If the employee turns around and says, I don't need anything, I'm fine, well, then you fulfilled your obligation. And then you can follow up with, okay, you just keep in mind that you've had some performance issues. We expect you to, improve upon them. And that is required of the job, but you've done what you needed to do, okay? And the supervisor can't sit on that information. That's really important. So if the supervisor is told that the employee has some condition, they need to act upon that.
Just one quick point, because Marianne and I have seen this time and time again. It's a different point, but a related point. We've had a lot of cases where the day of termination, the person shows up and goes, oh, by the way, I have a disability, right? And all of a sudden becomes this conundrum of, now we're firing someone who just told us they had a disability. Yeah, in the same conversation. If you intend to terminate someone, document the intention to terminate even before you tell them they're terminated, because that piece of evidence, that document showing that before they told you in that same meeting they have a disability, you already decided to terminate the person. Otherwise that, temporal proximity, this all happened in the same meeting. We have seen it being distorted into retaliation. I came in just for a meeting about my performance. I told them about my disability. They heard me utter the words disability or whatever the words are in need for accommodation, and they canned me. If you're going to terminate someone, document the intention before the actual date of termination.
Absolutely, that's come in handy many times. And just sticking with another example, I know a lot of times with these presentations, people like the examples about not, you can't be in the dark, you can't ignore what you know. I recall a situation where the employer knew, the whole office knew that a person had diminishing eyesight. They sat at the front desk, they were in charge of checking in patients. And they were making errors, giving the patients the wrong forms. They couldn't enter the correct information on the computer. There was enough for people to know that that person was poorly performing because of the diminishing eyesight. And then we counseled them on engaging in the dialogue. You know what? They could be a magnifier on the screen. You can color coordinate the forms. So again, there's that notice thing that you can't ignore once you're aware of a potential situation. Okay, so move the slide to the next one. Also important is timely response, okay? So one of the things you have to do is once you find out the information or the request, right, you got to act upon it. That doesn't mean you have to act upon it in 24 hours. You have to give yourself time to gather the documentation, engage in the dialogue with the employee, but you can't wait a month, right? There are courts that have looked at things and they examine all the circumstances, but waiting 9 months to decide, even 30 days to decide, right? You're going to be put to task, okay, what did you do to move this process along? Okay, the employee made the request. It's fine that you asked them for documentation. Maybe it's the employee's fault that they didn't give you the documentation that was requested to engage in the dialogue. That's a reasonable delay. But if it took you 3 weeks to say, you know what, I got your request, by the way, I need 5 more things, you should have asked for that much more quickly. The other thing where we see situations where an employee might be out on leave, right? And you prefer them to be out at leave maybe because it's less disruptive than bringing them back with an accommodation. But the employee says, you know what, I want to come back, but I need an accommodation of X, Y, and Z, whatever it might be. Maybe some extra breaks, maybe a different seat, whatever. In that case, right, that employee is potentially being denied compensation because they think they can come back to work with a reasonable accommodation. You can't just say, well, they still have FMLA leave, let me leave them out for another 3 weeks. You've got to move upon those things. All right. So let's see.
All right, steps for engaging in the interactive process. First, determine what are the essential functions of the job themselves. Analyze, the job and determine what is its purpose, what are the essential functions, what are marginal functions, because that'll help inform that conversation about what is a reasonable accommodation. We've seen a number of instances where the employer did not accommodate but focused on these ancillary functions that weren't critical, that could have been handled by somebody else, but use that as the basis to say no. Second, establish the individual's limitations. Consult with the employee about the disability to assess, what are the precise job-related limitations. Maybe it could be that they're an OR tech or an OR nurse, but they can't lift more than 15 pounds or something like that. Try and get, again, specificity about what the limitation is and how those limitations can be overcome with the accommodation possibilities that are out there. Explore those potential accommodations with the employee. I mean, it's a two-sided conversation. Identify what they are, talk about how effective or ineffective they may be. Again, you're the employer. It has to work for you as well in order for it to be a reasonable accommodation. It's not necessarily, you can have a coincidence of alignment of interests in finding a resolution. It doesn't have to be what the employee wants. And, consider the preference of the employee. Why not? If it's reasonable for you as an employer and it's what your employee wants or prefers, that's called a great union. But again, you don't have to abide by that. Sometimes the accommodation may be so obvious that this dialogue might be 5 minutes. Other times it may take more time than that, depending upon what that limitation is, depending upon the size of the employer and what options may be in front of that employer. You get a solo medical practice, you may have more limited options. You're dealing with a hospital, the options may be plentiful. So that's going to be taken into account. Again, with regard to the essential functions of the job, if someone is an OR nurse, for some reason I'm focusing on them today, certain cases going on, don't say, oh, they can't perform certain paperwork duties or documentation duties, which may represent like 2% of their job description. So we're not going to, be amenable to a certain accommodation because they can't do that. Again, be honest with yourself as an employer about what or what is not important. In that regard, having job descriptions are important. They're important for other reasons as well, in terms of, wage and hour issues and so on. But for this purpose as well, if you have a job description, you can look at it and it will inform you in a really particular way what you need to do to find that accommodation. You don't have to have the job description necessarily, but it's certainly a helpful tool. As far as the disability is concerned, you're entitled to know, that an employee requesting an accommodation has a covered disability that requires a reasonable accommodation. We'll talk more about that medical documentation momentarily. Obvious versus non-obvious situations. If the employee seeking the accommodation that has a disability that is not obvious, you're going to want more documentation because you got to fill in the blanks, But if it's obvious, if someone's walking around with a limp or a cast on and they can't perform certain functions, again, that's going to inform how much you're going to be allowed to ask for and how much you really should ask for. I'm using a silly example, but hopefully you get the point.
All right, the next thing, which I think some of you are interested in documentation, right? What documentation can you get? I want you to understand, you can't ask for very specific diagnoses. At times they will tell you. People are very generous with information at times. You need to know what the general impairment is, right? Is it cognitive? Is it physical? You don't get, maybe they'll tell you I'm suffering from cancer and treatment. You don't get to know or ask, well, what kind of cancer is it? What's the extent of the heart condition that you have, right? Those things you have to be careful. What you need to know is, do they have an impairment, right? And you'll get a medical note for that. And the nature of the impairment, right? Is it, and when I say by nature, is it enough to know that it's cognitive, it's physical, it's mobility issues, right? Yeah, those are the details you need to, and you're allowed to ask about, okay? Then it's what activities does the impairment limit? So maybe they'll tell you they have an ongoing heart condition, right? I don't get to know exactly what the heart condition is. They might tell you, but it limits the ability to lift, pull, and push, right? So what are the activities that are impaired, right? What are those restrictions? And then the extent to which that impairment limits the ability to do the job functions. Like, what is it about that impairment that affects the job? Okay, that's really what you're coming down to ask for. So if you're told there's a physical impairment, often you can see that, and they have issues with walking, you're going to get details from them about, is it prolonged walking? Is it, long distances, being on your feet a long time? Those are the types of things you're going to get, and then how it affects the job, right? So is the doctor's note going to say that they cannot lift files or lift anything that's more than 10 pounds? They can't reach over their head, they can't pull, they can't push. Those are the types of things you're going to be asking for. Let me go on.
Also, just you see up on the board, also the duration of the impairment.
Oh, absolutely.
Because it might be that, somebody has whatever the condition is, and again, you're not going to ask for the specific diagnosis, but maybe it's only for a week, maybe it's 2 weeks, or maybe it's just indefinite. And the length or duration of that impairment, again, it's going to inform both parties about what is reasonable or just unachievable.
Right, and that's critical because there are many times where people will tell me, they need this accommodation. They won't be able to do basically 90% of the job, but then they tell me it's for one day. And I'm going to say, you know what, you got to get over that. So duration is really a key if it's temporary or indefinite. Okay. So things you can ask for, things like the complete medical record. People get obsessed with wanting to know the details, every aspect of this health condition. Sometimes it's out of being nice. Maybe they're in the medical profession and they think they're going to be able to help and provide medical advice. You got to stay clear of that. And you don't get to know about unrelated disabilities. So, the heart condition may be affecting the work performance, but maybe they also have a bunion, right? You don't get to know about the bunion because it has nothing to do with their job, okay? So you got to be specific, and you can ask for a medical file. I also stress that people shouldn't be calling up employee doctors and saying, well, I'm going to ask what they need. That is very dangerous because you could be getting protected health information to which you're not entitled. You're going to ask the employee to get the relevant information. There have been some cases where I thought I got a fraudulent note, and we have drafted letters to the medical provider that simply say we received X note from your patient and we're calling to confirm the veracity of the note, or that, this was indeed issued by your office. And a few times we've gotten that it wasn't. So, you can get a lot of these medical notes now off of the internet. Usually there are some telltale signs. I've become a little bit of a police investigator in ways in examining physician notes or COVID tests. Apparently you can get a lot of those off of the internet too, positive COVID tests. We have another question, let me see, is what if the accommodation causes an undue hardship on coworkers by the need for them to do extra call, causing the business to pay time? Yeah, so, and I think we're gonna talk about that a little bit later, but what is an undue hardship is a lot of different factors, right? Bigger companies, companies with resources, right? Having to pay for a temp isn't going to get you out of providing a reasonable accommodation. Remember, there's a little bit of an overlap too with FMLA, family medical leave. Leave is a reasonable accommodation, whether or not they're qualified under FMLA. And at times you have to hire a temp, and there is a cost to that. You still have to deal with it. Coworkers are going to have to, chip in and maybe take on some more responsibilities. Again, it's a weighing of the factors. Can you operate, even though it's inconvenient, even though it's maybe disruptive, but you're going to look at that duration and how feasible it's going to be to make that assessment. Just because it's more difficult and it isn't ideal doesn't mean you're going to get a pass on that. I see.
Just to piggyback what Marianne said, until 2000, I was going to say 1923, 2023, undue hardship, yeah, it was something more than something minor. The U.S. Supreme Court ratcheted up what the standard was, made it tougher for employers. Saying that undue hardship means something severe, something that's unjustifiable. And it goes to answering that question, just because coworkers may have to involuntarily work some additional hours, it does not constitute undue hardship. So again, we're just using that as an example in response to that question. It's not such an easy standard to meet anymore. You look into a whole bunch of factors, as Marianne said, but the standard has gotten a lot tougher.
Absolutely. Yeah, there are a few questions, actually a flurry of them. It's gone over to the next page, but just because you ask for a HIPAA release to speak to the provider, that's not appropriate, right? Because you're asking the employee to give you permission to ask for information you're not necessarily entitled to. So you shouldn't be asking for HIPAA releases. Again, you're going to ask for appropriate documentation that will confirm an impairment that affects the job-related duties, right? And if it looks insufficient, and we'll talk about that in a minute, right, you can ask for additional information. But I would caution anyone from trying to talk directly to a doctor and getting additional information that wasn't authorized by HIPAA or otherwise, by a HIPAA release or otherwise.
It's actually a practice that can expose you to liability, because the way that could be spun, if it doesn't work out with that employee, my employer demanded to know my protected private health information, and when I refused to give something the employer wasn't entitled to, I got fired, right? So stay away from that.
With the fake notes, I don't want people to just, focus to, yes, we've had some fake notes. It's not all the time. Usually there's some surrounding circumstances that are going to make us question it, right? That they've asked for vacation a particular week, all of a sudden you said no because you didn't grant the vacation request, now they're sick. There's probably more chances of it might be fake, but I wouldn't get into the habit of necessarily calling people out on fake notes every time you got a physician note. It could affect employee morale and engagement. Do it when it's appropriate. If you have reason to believe it doesn't look like the letterhead is crooked, there's not signed on there's all kinds of telltale signs where you have to scratch your head and say, this might not be right. And you can absolutely terminate someone for a fake note. We've done it quite a number of times when people were getting paid COVID leave and they're coming up with fake COVID tests, if we were able to confirm that, they were getting terminated. Okay, so what slide are we on here? Oh, for documentation here, I think we covered this slide. Let's go to the next one here.
All right, insufficient medical information. It's insufficient if it does not both specify the existence of the limitation or disability, again, not the diagnosis, and explain the need for the reasonable accommodation. Okay, it's the ground that Marianne covered before. It may also be insufficient where the healthcare professional does not have the expertise to give an opinion about the employee's medical condition and the limitations imposed by it. One case that comes to mind, a social worker writing about a medical condition. Aside from the speculation that it might be someone's relative who was a social worker who said, I'll just write a note to help them out. Social workers aren't qualified to talk about medical conditions. If the information does not specify the functional limitations due to this disability, it's insufficient. And kind of what we said before, if there's reasons to believe that there's fraud involved or other reasons why it's not credible, you're not bound to act upon it. Conversely, sufficient medical information, just, flip side of the same coin. What activities, what are the specific limitations that employee, suffers from? Describe the extent, and I'm just using the easy one, the lift pull push that Marianne talked about before. You can't lift a certain, an object beyond a certain weight. Again, we're not talking about pages with regard to what is sufficient or not. A lot of times you get a doctor's note and they just nail it, in a few sentences, and you're good to go as far as, saying, okay, I now understand what the impediment is that has to be overcome, if possible, by that discussion. You want to be careful, and it goes to Marianne's point too about don't start saying, well, I suspect that this might be a fraudulent note, denied, right? You want to make sure that you're on firm ground, because if you wrongfully reject information that was otherwise sufficient or arguably sufficient, you might expose yourself to a retaliation claim. I told you I have a disability or a limitation and you canned me because of that. Look at how you responded to my medical documentation in that wrongful manner. So you want to be careful about rejecting something, out of hand. If there's questions that need answers, then certainly follow up and post those questions and get the answers you're entitled to. But again, walk a fine line.
Yeah. Okay. Oh, is there another question? I'm sorry, I'm squinting because the screen is a little far away from us here. How long is considered reasonable? You've accommodated a year and they're issuing the condition as no end to say, oh, I love this question. So yeah, it comes up quite a bit. And some of it's going to be dictated by your state or your jurisdiction. And, family medical leave is generally 12 weeks. Some states have some longer periods of time depending on the condition. But there are even jurisdictions that will consider indefinite leave, and I know that's a hard pill to swallow. Indefinite leave could be a reasonable accommodation. So it really does come down to the total scenario and the facts, so maybe you're a big hospital, being out for a year or more than a year may not be an undue burden, right? It's all going to be fact specific. There is no bright line rule or rule book on what's considered reasonable as far as duration. It's going to be fact specific. I've had many clients that say, well, they used up family leave, I'm going to terminate them. I'm like, oh, no. Once that law is done, right, they're protected leave under the Family Medical Leave Act if they're qualified for it. You then have to assess whether or not time beyond FMLA. I know we have some clients that are bigger corporations that may provide under a union 1 year of leave. Again, that's protected under the union for 1 year, but that doesn't mean under the applicable state law, maybe they need 2 more weeks off, and I'm going to say it might be reasonable to give that extra 2 weeks.
On that point, and it goes back to what I said in the introduction about reach out to us in the moment when you're dealing with, for example, that particular situation, because better to spend a half an hour with us than to spend years with us in a litigation. Why do I say that? We understand fully there's a natural tension line between HR and the people on the ground, the supervisors who are handling the job, who are saying, I can't run with 4 people in this unit. I need 5. It's been 6 months already. Or they're done with the FMLA leave. What do you mean we can't fire this person? And HR is going back and forth trying to keep them, in some safe lanes and so on. Have that conversation because it's factually specific. It's a case by case assessment. There's no, indefinite leave, you got to give it.
Right.
Maybe yes, you do. Maybe you don't. Depends on the jurisdiction. Whatever the accommodation is may depend upon the facts. We've had that. They've exhausted, and there are a lot of different leave laws out there. They exhausted every form of leave. Can I fire them? No. Interactive dialogue.
Right. Okay. All right. The next thing I want to talk about, confidentiality, right? So that one is pretty critical because we've seen claims crop out of these accommodation requests because an employee may give information, health information to their supervisor, and it starts spreading to other people, right? And then people are going to get very sensitive about why you're spreading my protected health information. Or let's say you have an employee requested to leave early every day, right? And the coworkers are really annoyed that so-and-so is leaving early. You as the supervisor are trying to say, well, I'm trying to, give them the information to make them understand why so-and-so is leaving early, but you're really not at liberty to give that protected health information to the coworkers, all you who are burdened by the extra work. What you have to say in the nicest way or in whatever words you want to use is something along the lines of, I understand that so-and-so is leaving early. There is a reason for that. You need to respect the privacy of your coworkers. We work as a team, and so-and-so has been given permission to leave early for, the next 2 months. And we're not going to discuss that any further. And we expect everybody to do what they're supposed to be doing, blah, blah, blah. You got to cut down the rumor mill. You as the employer too, or the supervisor, you can't huff and puff about it because then you're going to get a disability discrimination case, right? You might be annoyed and you're like, oh, that person's out again on leave. I can't. You might not even mean anything by it. But we've seen those allegations. Oh, the person's pregnant again. How many kids are they going to have? They're constantly taking leave or whatever it will come back to bite you. I mean, it's also from a morale standpoint, when people see their supervisors or managers vent about people who are taking accommodations or have disabilities, it really does affect the work environment. And the person who has the disability may feel targeted, may feel it's a hostile work environment. Everybody hates me now because I'm leaving early Monday and Friday, and they think I'm just going to the beach, but here I am, I'm having radiation treatment, right?
Or it may burn you in a cascading way. You're the supervisor, you're groaning and complaining about so-and-so having another baby. An employee, a different employee hears that, doesn't say anything, then she becomes pregnant, gets fired for performance issues, and claims pregnancy discrimination, and is able to say, on April 4th, 2024, Supervisor Smith was talking incessantly about how that other employee was having a, umpteenth kid, and it was overheard by other people. We've had those situations as well. So, avoid that. Let's put it simply.
Okay, is this you exploring? No, this me. Okay, so exploring accommodations. Key is acting in good faith. I don't want to be repetitive of stuff we talked about before, but look, you invest in these employees. We've done classes on employee engagement. It's going to bode well if people, even if you don't grant the accommodation, show that you really listened to them, you assessed it. Other employees are going to see that. You'll get loyalty, especially if you provide an accommodation that's fairly reasonable to give, you'll get that employee loyalty. So that is important. And then if there's a question about whether or not you engaged in the interactive process, courts are going to look at, well, what did you do? And good faith is going to mean, I met with the employee, I requested information, I listened to them, I talked about reasonable alternatives, right? All of that stuff is going to go to showing that you engaged in good faith. There's also a duty to provide information both by the employee and the employer. Employee has to give you the medical information that you need to make the assessment. But the employer can't sit back and say, well, I know I have this other opening in this department that I'm sure that employee can do, but you know what? It's such a pain in the neck to transfer them. I'm not even going to tell them about that vacancy that I can slot in as an accommodation. You will get in trouble for that. We've had pending lawsuits about, failure to discuss reasonable alternatives. A temporary job change, and I think you're talking about some of those, can be a reasonable accommodation. So again, it's a two-way street about that.
Yeah, I mean, this slide, I'll just spend 2 seconds on. It's really the bottom of it. Your failure to engage in that interactive process, it goes to what Marianne just said, may be prima facie evidence of bad faith. In plain English, it means that if you don't have the talk you're supposed to have, a court or trier of fact that is examining whether or not you're culpable or liable as an employer is going to hold that fact against you in deciding other issues as well. So again, having that dialogue, it's not a heavy lift, and it is critically self-protective of you to engage in it. The next slide is hierarchy of reasonable accommodation options. You see there, these are just illustrative examples, modifying the job to remove marginal job functions, and that goes back to the job description. Having that, whether it's a pre-existing written job description or one which you're sitting with a supervisor and you're just going over, okay, what's critical, what's not so critical. Allowing workers to work remotely. It could be, something as easy as getting a different computer screen, if there's a visual impairment, et cetera. Granting leave over and above what they were otherwise entitled to under leave laws. As Marianne said, reassignment, light duty. It doesn't take much in most instances to be creative. Not in necessarily finding a solution. Sometimes you can't. Sometimes it just doesn't end well in that regard. But it doesn't take much deep thought and analysis to find something, to at least see what the possibilities are. If there are a bunch of different accommodations, again, as I mentioned earlier, you don't have to do what the employee wants. You get to make the final call as an employer. That said, as Marianne said earlier, if you can give them what they want and it's okay by you as far as the burden on you as employer, then that enhances employee engagement, and that's good for you in a host of other ways. With regard to reassignment, it's known as an accommodation of last resort. The goal is to try and keep the person in place without shifting them somewhere else, to keep them in place with whatever accommodation may be deemed reasonable. But if there is no effective, reasonable accommodation to keep them in place, reassignment is something you consider. You do not have to promote somebody as a reasonable accommodation. We've had those situations too.
Yep.
And again, you have the final word. Next slide, definition of or an effective accommodation. It's just one that's going to remove the impediment, to remove that workplace barrier and allow the individual with a disability an equal opportunity to apply for a position and perform the essential functions of that position, basically to level the playing field for that employee. Again, you have the right to choose the accommodation, mention that. Lastly, it's not on the screen. Document. I don't think, all of you probably have never attended a session about some, topic of employment law where the lawyers haven't said document. This is one of them. When you're having this dialogue, memo to file, email to file, something. So if it turns sour and you end up in a litigation, it's not just your word against theirs. You have some documentary proof that shows that you took the time to do what was right.
Yeah, and I'm glad you brought that up because I was about to go back to documentation myself, and I brought a sample that I was working with. An employee had given a doctor's note that was really generic, right? And they have a disability, it impairs their ability to function in the workplace, and they're triggered by overtime, after hours, phone calls, they don't want to do on call. Like basically they don't want to talk to too many people because that's going to trigger whatever this condition is, right? But they had like the highest level position in a medical facility, right? So All right, and I can glean off of it from and I'm paraphrasing, right, that there was some cognitive issue that was going on. So we wrote a letter to the person, again, documenting that we're in good faith doing this. And I'm going to paraphrase some of it. It's like, I want to confirm receipt of your request, our commitment to engaging in the process, and dialogue to consider reasonable accommodations that will allow you to return to work. I'm going to skip over a few things here, but your physician's note made various accommodation recommendations. No direct reports, no after-hour communications, limited 40-hour work week, no overtime, right? So then we say, okay, we need some more information. We need additional information upon which we may confirm that you have a current disability condition, setting forth the functional job-related limitations necessitating the accommodation. And then how you propose that your requested your accommodations will allow you to perform your essential functions as X. And I parroted back some of the job descriptions in here. And then I also make note that, and after we get this, we're happy to discuss the accommodations or alternatives that may meet your needs while ensuring the effective operations of the organization, and in this case, it was patient quality of care, right? So I documented that, okay, I got it, I'm here to listen, get me this stuff, and we're gonna sit down and discuss it, right? And then what was great in the next go around, when we got more information, we made that assessment and saw that, okay, this person had this job, was responsible for, crisis situations, crisis management, all these kinds of things. We could recite to the job description, as Andrew was saying before, how important that is. And we were able to document why and explain why the requested accommodations did not reasonably work from an operational standpoint, safety standpoint, patient quality of care. And it worked out very smoothly, but we had it very well documented to make that request. Miraculously, the person was able to come back to work.
And with documentation, do follow up. Like if you're having a conversation or this dialogue with the employee, and let's say it's about, I need more leave because of some condition, right? Don't just say, oh, we never heard back from them, right? Follow up with them. It could be an email. Susie Smith, we had requested the medical documentation a week ago. We haven't received it. Because if there's a persistent failure of them to respond, that itself can be used as a basis for termination. You don't have to have this dialogue endlessly, but we have had instances where that follow-up was done and it proved to be very helpful when there was a termination. But one case stands to mind when they didn't do the follow-up, they terminated the employee. And when the employee was otherwise unavailable because he was in the ICU for 4 days,
Right.
came out of the ICU, we found out he'd been fired, right? So do the follow-up. Again, it's not onerous. It makes sense. It's fair. And it's also self-protective.
Yeah, and if you're a bigger company, we've seen situations where, you make the request for the information, and I've had clients forget about it for 6 months, but you forgot about it. So then they say, well, now we're going to terminate. No, let's put another, as Andrew's saying, another reach out and give them a deadline to respond. Deadlines are good. You rein it in, so it's not like you're leaving it out there forever.
Because in those situations, the comeback's going to be, you're okay with it for 6 months. I'm asking now for another 2 weeks, and it's a problem. Right? So your lack of follow-up in that instance is going to hurt you in a big way.
Absolutely, absolutely. And one of the questions, which is nice to hear that you want our names, which will definitely be at the end of the program, Marianne Monroy and Andrew Zwerling. So again, if anyone needs to reach out to us, that's fine.
And again, all of the materials, the PowerPoint, there'll be a CLE outline. It's all going to be provided to you when you follow that link.
Absolutely. So, okay, so, and we're nearing the end of this, and some of this is just a summary of what we've already discussed. And look, the breakdown of the process, this is where courts are going to look at it, right? And most of the time, these are questions for a jury. We usually don't get rid of these types of cases on a failure to accommodate on what's called a summary judgment motion, just on legal papers. So having that documentation and proof that you engaged in the good faith process is what we're going to be looking for. And again, engaging in the dialogue does not mean that an accommodation necessarily exists. So I don't want the takeaway to be, well, whatever they ask for, I'm going to have to give it. That's not what we are suggesting. We are suggesting that, not more than suggesting, recommending that you hear everybody out, have that process, and weigh the pros and cons to see what is reasonable or not. So for instance, I remember the CMO of a hospital who wanted to work remote during the pandemic. Not so reasonable. Maybe we could have gotten that on summary judgment, but I don't know. But those are the types of things that you have to consider. And then the next thing, and we're going to kind of tick through these really quickly. And again, you'll have these materials. It's the overview. Meet with the employee, get the doctor's note, ask for additional information if you need it. Again, you'll have all of these documents at your hand. Then you do the assessment. What's being requested? In this case, this assessment is regarding leave, how much leave, for how long, how the frequency, what's the flexibility. You're going to deal with all that. I will mention there are certain things when it comes to intermittent leave, which is protected under FINLA. Those are trickier, right? There are certain conditions where I'd urge you to give us a call. Migraines, lupus, those unpredictable conditions where people can have flare-ups, colitis, right? And there is no schedule you can necessarily work with. So it may be a situation, depending on the job, where that if there is such unreliability and it's a critical job, we're suggesting something reasonable as a change in job that is more feasible. But it's all going to be fact specific. So with that, because I think we have about 2 minutes left.
Yeah, just a question. Where do we find the link with the presentation slides? At the beginning of the chat box, there was the link in the chat box itself. So you'll find it there. Let's just go to the last slide. Yep. Just to dot the I's and cross. We already.
Am I going in the wrong direction here?
Yep, there you go.
There it is. Okay.
I'm just going to step in before Marianne speaks about some of the best practices and caution you, don't use your desire to get rid of a poor performing employee. Don't let that influence your decision making on how you're going to handle this process, because we've had those situations too where the employee goes, really, I'm not crazy about this employee, and use that as, let me just say that there's no reasonable accommodation, right?
Mm-hmm.
I'll cut that dialogue short. It's just, if anything, you want to play it smarter on some level, because that's the person you're going to terminate, as opposed to, as a general rule, and I'll hand the baton to Marianne, your goal is to succeed. Chances are, in most instances, you have a decent employee, if not a really good one, and you want to make it work.
Yeah. Okay, I'm happy to go through I thought you were doing these, but yeah, aim to succeed, be creative. Sometimes there's a job or a need within an organization. So when I say creative, sometimes there's a role that might make sense for the organization. I'm dealing with one last week, right? Look, there's a shortage of such and such employee. We weren't posting for it, but maybe this will work. Or maybe we can divvy out the work in a different way, right? Keeping everybody involved, documenting, we talked about. Not blaming people when things are the breakdown. Take accountability. Sometimes you might forget to follow up, right? Say, look, I know I asked you for this. I should have followed up with you. Again, it's having that positive dialogue, spending time on the process. Don't make flip decisions without getting all your facts, getting all your information, because that is what's going to support your actions if we have to litigate this, okay? And I think that's really, some of this is common sense. Some of it is a little painful when you're trying to operate a business. We totally get that. But that's where the being creative may come into we have to give a code. I know that everybody wants that code.
Well, also, just if somebody could just write, let us know. Our IT department put the link in the chat box just now. Just if someone could just write back saying you all can see it. So we know that you have it.
It's like a onehub.com link.
Yeah. Perfect.
Okay.
As far as the CLE code is concerned, it's A as in Apple, R as in Red, G as in Garfunkel, W as in Walrus, 44. Again, A as in Apple, R as in Radish, G as in Garfunkel, W as in Walrus, 44. Again, thanks everybody for attending today, and hopefully we'll cross paths.
Yes, yes, and our names are now up there for those who put that in the chat box looking for our names. But again, it's a pleasure to be with you here today and look forward to presenting at the next program and have you join us.
Thanks, everybody.
Have a good one. Bye.